Thank you very much. The subject is promoting children's access to legal representation, and I'm going to focus on the need to provide access to justice to children who are in police custody. And I'm going to do this in a way that is a little different, I think, than the presentations that have gone before. I'm going to tell you a story, and I'm going to do that for the reason that I think stories can be particularly powerful in educating those who need to be educated about the importance of providing early access. I'm going to tell you a story, then I'm going to talk a little bit about the way in which justice stakeholders in Cook County and around the country have gotten together to make concrete suggestions about how to provide access early on in the process. And I'm going to focus really on the need to provide early access at police stations based on this story that I'm going to tell. Can we go to the next slide? Statement of the problem is that children are taken into custody by police and are not allowed access to parents, guardians, friendly adults, or legal representatives, and such access is obstructed and not facilitated. This is true in our locality, despite the fact that we have very strong statements in legislation, in our constitutional law, that would indicate that the practice should be otherwise. But in fact, it is not. And I suspect that this is a common problem throughout the world. We have the laws on the books, which are quite good, but in actual practice, we all fall short in enforcing them. Next slide, please. The consequences of the failure to solve this problem, we've talked about maltreatment, especially of children, separation from families and communities, involuntary and unreliable statements. We have a spate of wrongful convictions, especially among juveniles in our locality and in our country. And then, of course, we have charges filed without all necessary information. Next slide. So the story I wanted to tell you just briefly is People versus Hester. It's a case that was initiated by our Cook County prosecutors back in 1961. When I was in high school, I heard about this case. And then as I became a lawyer and started practicing juvenile law and was concerned about the admissibility of confessions, this case was always cited against me. And as you can see, it still remains good law with respect to the voluntariness of and the admissibility of a confession. And this was a very compelling case. 14-year-old, mentally disabled, parents, mother was not permitted to be present during the interrogation. Statements taken by an experienced prosecutor with police present, allegations of abuse, and yet the confession was found to be admissible. I'd always wanted to know, well, who is Lee Arthur Hester? What is the actual history here? And about 5 years ago, I actually went back into the records, and I have provided in this presentation links to the history, links to the case. The case went up to the United States Supreme Court. It was eventually dismissed because the Supreme Court of our country didn't really want to reach the issues involved. And we have a link actually to the oral argument in the court. Now these links, I'm not sure are functioning properly in this PowerPoint, but I'm going to work out the technology and hopefully we can get that information to you. Next slide, please. So what are the solutions to this problem? Well, of course, the UN guidelines, as noted here, provide very specific guidelines for the solution to the problem of police interrogation at a police station without the presence of legal representative. And increasingly in the United States, these principles, I should say international standards, are in fact being recognized by our courts despite the fact that we have a long history of hostility toward the reliance upon international standards. Next slide. So what are some of the responses that can be made to the problem that the People versus Hester case describes? Well, we have some legislation in Illinois that require minors under the age of 13 to be represented before a statement can be made. We also have legislation that requires juveniles charged with serious felonies be videotaped. So that's a protection. Next slide, please. We also have organizations that have been founded by lawyers groups, one of which is an organization called First Defense Legal Aid. It was founded by a group of lawyers, including myself and others of my colleagues who have been involved in the legal services programs in Chicago. It is a hotline served by volunteer lawyers. Other 24-hour services have been described by the participants in this conference, but this is a privately funded NGO that provides round-the-clock access to counsel especially for children who are either detained as witnesses or as defendants in the police station. There's a cost-effectiveness study that is part of your materials that I sent to the organizers of this conference, demonstrating that the implementation of the requirement that counsel be present at the police station actually, in the long run, saves the system money. Next slide. We have also cooperation between prosecutors and defense lawyers. So we have a handbook that suggests that police are generally in favor of recording custodial interrogations. The author of this study is the former United States Attorney for the Northern District of Illinois, so he has special credibility with the police. We have a study that we worked with, which we worked with the National Association of the Chiefs of Police and OJJDP, that talks about best practices in taking statements from juveniles who are detained by the police. And I should say that this is an initiative that is an example of what clinical programs can do, what law schools can do to get involved with the prosecution to address this problem. And again, I have a link in the materials. I don't know why it's not showing up on this PowerPoint, but again, I will make every effort to make this presentation available to you, and the links should be evident in the next draft. Next slide. We also have litigation, and of course, we have some fairly recent United States Supreme Court opinions that talk about the special vulnerabilities of children. And of course, Roper versus Simmons incorporates international standards. The decisions regarding life without parole that have more recently come down from the Supreme Court also, I think, are based on Roper versus Simmons, and I think highlight the importance of the work that you were all doing in the international sphere. Back to People versus Hester. When I met Mr. Hester finally, after 40 years or so, he didn't expect my call. And when he became aware of the fact that we were looking into it, he broke down, he sobbed. Because in fact, he is, we very strongly believe, innocent. And his conviction was based on an unreliable confession. There's evidence of an alternative suspect that we're trying to develop, but you can imagine that after 40 years, it's a little hard to find all the evidence that might exonerate Mr. Hester. There's an article that describes fully the case of Mr. Hester in our Journal of Law and Social Policy, which I will also make available to you. One question that we're facing is, what is his remedy after 40 years? And I won't go into the details there. But when we do hopefully exonerate Mr. Hester, I'm confident that this story that is embodied in the research that we've done will be a very powerful argument in support of the need for early access to legal representation for children at police stations. So thank you very much.